they said to look at all issues. The NHRC, however, decided to limit its jurisdiction in two important ways. One was by only looking at the identification of the bodies and payment for the cremation of the bodies without looking at how these people were killed and abducted in the first place. The other issue is that the NHRC chose to only look at the three crematoria that Carla was able to look at and did not look at what was happening throughout the state while the mass abductions and murders were throughout the state. The Armed Forces Special Powers Act, or AFSPA, has its origins in a similar ordinance promulgated by the British in 1942 in response to the Quit India movement. It was an oppressive law designed to be used by a foreign occupying force with the goal of forcing an oppressed population to submit to its will. Unfortunately, the Indian government not only adopted this act in 1958, but it has actually been even more draconian in its use of the law. AFSPA has been in effect in Manipur for over 50 years, and that law helped create an atmosphere of impunity in which all security forces, not just the army, felt they could get away with murder. To discuss the extrajudicial killings in Manipur and the role of the NHRC in properly dealing with these killings, we have with us today Mr. Bablu Loitimbam. Bablu is one of the most well-known human rights activists in Manipur, and with good reason. He was a 2000 Ashoka Fellow for his work on behalf of victimized communities, and he's the founder and executive director of Human Rights Alert. Bablu was also instrumental in systematically gathering information about the extrajudicial killings in Manipur, and the information he gathered was used to file a Supreme Court petition in December of 2012 against the Government of India, the State of Manipur, and the NHRC. He'll be speaking as an expert witness, and the cases will follow afterwards.
Start with a small personal note, because very often for people coming from Manipur, we always complain that we are underrepresented. I think, among other things, today's panel is perhaps the only panel which we see Manipur overrepresented. There are already three members of the Manipur Human Rights Commission, and also Professor Chinoy and Anuradha Chinoy, who have been in and out of Manipur for so many times, and of course Justice Suresh, who triggered Irom Sharmila to hunger strike. So in a way, I feel very comfortable to speak in this the jury. To begin with, we all know that the Protection of Human Rights Act have limitations in terms of taking up cases of armed forces. Section 19 is quite well known. But I would like to also draw your attention to the fact that the National Human Rights Commission has been very ambivalent on its position on the Armed Forces Special Powers Act. In the morning, we heard Murthy talking about how National Human Rights Commission have taken a position on TADA, and they have written to each and every member of the parliament on its position on TADA, which ultimately led to the lapse of TADA. They did similar things on POTA. On POTA also, they wrote to each and every member of the human rights, the member of parliament on their position on POTA. But the oldest draconian law, which I don't have to describe again, have all kinds of colonial mindset of a bygone era of a law that is used in a wartime continues to be in the statute book. There continues to be all kinds of protests, 14 years of hunger strike, and till date the National Human Rights Commission is completely ambivalent about its position on Armed Forces Special Powers Act. I think my humble submission to the jury today is that we need to press the National Human Rights Commission to come with a clear position on Armed Forces Special Powers Act, and in the same way that they have done with TADA and POTA, should write to each and every MP of this country about its position in compliance to India's constitutional obligation as well as its obligation under the international covenants, which has been very well exposed. All the United Nations treaty bodies have come very clearly on their position on Armed Forces Special Powers Act. Interestingly, though, if we look up the Supreme Court judgment which upheld the Armed Forces Special Powers Act in 1997, there Dr. Rajiv Dhawan represented the National Human Rights Commission, and they also very clearly stated in that, in the records, in the judgment itself, that APSFA is ultra-virus, and the Parliament cannot enact a law like this because it falls within basically maintenance of public order, which is a state subject under entry 1 of the state lease. And therefore, it made its position very clear. But unfortunately, once a judgment was passed, where again the judgment, which has been considered one of the most conservative judgments in the annals of the Supreme Court of India, the National Human Rights Commission has kept absolutely quiet thereafter. This has led to the civil society in Manipur to invite Justice Suresh, Colin Gonsalves, and Priti Burma, and we constituted what is called the Independent People's Commission of Inquiry in 2000. And there we did exactly what the Supreme Court left. Supreme Court simply interpreted the text of the law and said they believed in the premise that the Union of India and the Army was giving, which is that if there is any allegation of human rights violation, we go and do inquiry, and if there are substantiated, then we take action against the erring armed forces. And they also say that there are do's and don'ts which are given by the armed forces headquarters, and therefore this exercise of killing people on suspicion is not arbitrary. But what we wanted was, we wanted the Supreme Court to look at the actual human beings who are living under this law perpetually for decades together. And this is exactly what the Supreme Court ignored. And this is what we invited Justice Suresh and his team to look into the matter. And Justice Suresh, who's also very much in our jury, concluded that the do's and don'ts on the basis of which the Supreme Court upheld the law is followed more in breach than in compliance. This is his exact words, and I would like to repeat that. And he also made a statement in public saying that a sanction to kill can never be constitutional, irrespective of what the Supreme Court have said. This has led to a big debate, and one of our volunteers in that People's Commission of Inquiry, exactly after a week of the completion of this inquiry, there was again a massacre where 10 civilians were mowed down in a bus stand in Malom village, where after which Irom Sharmila went into a fasting and have gone into this unprecedented fasting in human history, 14 years running, and still National Human Rights Commission have no time to discuss Armed Forces Special Powers Act. 2004 was again when preambular paragraph number 3 of the Human Rights, Universal Declaration of Human Rights says, human rights should be protected by rule of law. Lest people resort to rebellion as a last way to fight the tyranny. And I think 2004, that happened exactly. After Manorama's rape and murder, Manipur was completely ungovernable for 2 months. The Prime Minister came down and promised the people of Manipur that this act will be replaced by a more humane act. And that's how the whole movement calmed down. This was followed through by the Prime Minister appointing a high-level committee headed by Justice Jeevan Reddy, which also involved, where the brief was that national security cannot be challenged under circumstances, but the committee was asked to formulate a way in which national security can be protected, but at the same time, human rights, fundamental human rights would not be trampled. The committee include General Raghavan, who was the Director of Military Operation, who know exactly how much strategic requirements in terms of India's defense is. It include Home Secretary Mr. Srivastava, who was also dealing with internal security all throughout his career. It include Mr. Juris and Sanjay Hazarika, a journalist from the Northeast. And they came out with a formulation wherein they said that if these do's and don'ts are indeed criteria that the army follows, make it into a law so that a civilian, when a citizen's right is being violated, they can at least go to a complaint mechanism and enforce this in the court of law and let the judge decide whether it is the interest of the soldier who is fighting, quote unquote, for national security, or is it the basic rights of this individual which needs to be weighed, and let a judge decide. That was the recommendation of the Jivan Reddy Committee, and they said, it is true that the Supreme Court has upheld its constitutional validity, but the circumstances is not an endorsement of the desirability or advisability of the Act. The Act, for whatever reason, has become a symbol of oppression, an object of hatred, and an instrument of discrimination and high-handedness. It is highly desirable and advisable to repeal this Act altogether. This was the conclusion of the Jivan Reddy Committee. 2005, June 5th was the day this was submitted to the Government of India. The Government of India have not accepted the report, neither have they rejected the report, neither have they published this or made public or made a discussion in the Parliament. It is kept as a closely guarded secret. Thanks to Hindu, they have leaked it out, and you can see this. After this, again, the National Human Rights Commission has been completely quiet on the Armed Forces Special Powers Act. They opened up only when the UN scrutiny came. It was only when India went for reporting for the second time in the Universal Periodic Review that they start mentioning about Armed Forces Special Powers Act, saying that it is incompliable to the position that there is no armed conflict in India. Interestingly, the clearest position of the National Human Rights Commission came when the UN Special Rapporteur on Extrajudicial Execution, Mr. Professor Christoph Hans, came to India in March 2012, wherein in the meeting with the the NHRC, Satyabrata Pal, the friend of civil society in the commission, have clearly stated that we want this act to be repealed. But because the Supreme Court have upheld it, it is the duty of the government to take a position on this. I thought I heard something Henry saying in the morning that one of the role of the NHRC is to advise the Government of India on what they need to do to uphold the human rights in this country. Why, if the Government of India is not taking a position, why is the National Human Rights Commission not advising the Government of India till date is something that I cannot understand so far. Special Rapporteur in his report submitted to the UN Human Rights Council as well as to the General Assembly said that in his conversation with the National Human Rights Commission, the National Human Rights Commission clearly stated that this act needs to be repealed. However, in 1997, the Supreme Court upheld this act, and he said he still cannot understand how the Supreme Court have come to such a conclusion that it doesn't violate the Constitution of India. The representative of Government of India in Geneva was very worried about this position of the UN Special Rapporteur and made a formal complaint against the UN Special Rapporteur for disrespect of the Supreme Court of India, which is held at the highest esteem. What is interesting is that Justice Burma, who was the leader, the architect of the 1997 judgment, when he was in his next avatar as the chair of the Burma Committee, we talk about 16 December incident, that was perhaps the first time that Justice Burma actually came in contact with women from the Northeast. And when the women of the Northeast